But I'm Lee Leppert. I am the Senior Creative Manager here at the Cromings Law Firm. And today we have Joseph Munoz. He's the Associate Attorney here at the Cromings Law Firm. And he's been a practicing attorney since 2008 and is here today to break down everything you need to know to best protect yourself and your business before an issue arises. Do you understand the differences between termination and default in your construction projects? Most of the times the words termination and default are used interchangeably, but they really mean two very different things. Understanding how defaults and terminations work, as referenced in a subcontract, is essential to your company's success. And learning everything you need to know about terminations and default today with convenience clauses, preventative steps that you can take to best protect yourself and your business due to the convenience clause. Your business depends on your knowledge of these essential concepts. So please reference the handout that I sent to you last night and today to fill in the blanks as we go along with the presentation. We will have a Q&A at the end of this presentation, so please feel free to submit any questions you have via the chat. You can also unmute yourself and ask direct questions to Joseph. This is the perfect time for you to get every kind of question you need answered by him, and please take advantage of this time. Okay, without further ado, I will let Joseph take it away.
All right, thank you all for joining us during your lunch hour. Today we are going to be talking about termination versus default, knowing the differences. And as Lee said, that most of the time these words are used interchangeably, but they have very different meanings. And not only do you need to understand the meanings behind them, but how to react or behave when one of those happens to you as a subcontractor. Knowing the difference and knowing what to do when they happen could mean the difference between you getting paid, not getting paid, or ending up in court. So we're first going to talk about default. So you're considered to be in default when you do not complete everything that's required in the contract. That means that you must accomplish everything, that all the requirements in there, and that contract, as you know, could be 60, 70, 100 pages. So failing to even fulfill the smallest requirement could put the subcontractor you in default. Now, we gave an example. It could be anything from submitting labor reports or progress reports that you need to turn in daily. Let's say on a Thursday you get really busy, you're not able to turn in that report. Technically, you could be found in default just for failing that one small requirement. Now, so what happens when something like that were to happen? At that point, the ball's in the GC's court. Now, the GC at that point needs to put you on notice. So what does a notice look like? A notice of default is any written notice to you, the subcontractor, of any default that may have taken place. Now, here's the thing. That doesn't have to be a formal letter drafted by an attorney. It doesn't have to be sent by certified mail. It can be something simple as an email to you, or even a text saying, okay, you didn't turn in your daily log on Thursday. That technically is a notice of default. The most important thing for you to do as a subcontractor when you receive something like this is you always have to respond in writing. You can respond with an explanation, you can whatever that may be, or maybe even disagree with the claim of the default, but you have to have something in writing. The reason for that is, let's say this thing goes south and you end up in mediation or court. You want to have some sort of paper trail saying that you responded to these notices, you were proactive about it. Otherwise, you're going to be sitting in mediation and you're going to look like a negligent subcontractor. You have all these default notices sent to you, but you didn't respond to anything on paper. You could say that, you know, I told him this or I said this, but then you get into a he said, she said, and that doesn't really hold up in court because you're obviously going to have a written notice from the GC. So, of course, the most important thing, remedy the situation, put everything in writing, and cover all your bases when it comes to that. So the next slide is, why does it matter if I'm in default? Well, the bottom line is default can relieve the general contractor of the obligation to pay you. And of course, nobody wants to get into that situation. But the rule of law says that when you have an agreement, such as a contract with a subcontractor in GC, when one party fails to perform a requirement, it relieves the other party of the requirement to fulfill all their obligations. So in our example with the labor log, let's say you fail to turn in the labor report. You failing to fulfill that obligation means the GC said, look, you defaulted on the contract, now I don't have to pay you. So the general contractor doesn't have to hold up their end of the bargain. Now, this is why knowing exactly what's in the contract is so important. Now, you got to remember that this contract, the general contractor's contract, was written by attorneys, and they're not using everyday language. They're using legal terms, which can be confusing and hard to understand. And the purpose behind this contract is to protect the general contractor, not the subcontractors. In fact, in most cases, it takes advantage of the subcontractor. So you really need to not only have a firm understanding of the clauses and requirements in the contract, but you need to know what to do if something happens, if you fail to follow the change order procedure or the log procedure. You need to know how many times that can happen before something more severe comes your way. Now, next is termination. Now, as you might have guessed, that means if you've been terminated, you're fired from the project. It means that you have not completed your work, and the general contractor will complete your scope. Either they'll do it themselves, or more likely they'll find another subcontractor to complete it. There are two different types of terminations. The first is termination for cause. This occurs when you've been given a notice of default and you fail to correct the issue. Now, this is where, again, you need to know the contract details. You need to know how many times you can default before this termination clause kicks in. It could be 1, it could be 2, it could be 3. You really got to read exactly what you're getting yourself into. The second type of termination is termination for convenience. And this one is the one that usually gets subcontractors. When you sign a subcontract as a subcontractor, you're on the hook for all the work listed in the contract. You can't just decide what work you want to do, or when you want to do it, or when you're going to show up. You're obligated to do what's in that contract when it's assigned to you. Simply stated, you must hold up your end of the bargain. But the tricky thing here is the general contractor is not really held to the same standard. They have some exit clauses that are in their best interest, but definitely not in the best interest of the subcontractor. So it's critical that you understand what the clause looks like and how it affects you as a subcontractor. So we're going to take a look at some examples of what those those clauses look like. So here we have a termination for convenience. A contractor may terminate an agreement for convenience in whole or in part at any time without cause by its notice of such termination issued after conferring with subcontractor, and subcontractor shall terminate the work as instructed by contractor. Upon termination, if subcontractor has begun work, contractor shall pay to subcontractor in full satisfaction and discharge of all liabilities and obligations owed to subcontract with respect to work so terminated, the actual value of the work performed. All of this is just written by a lawyer saying, I as a general contractor can terminate you when it's convenient for me, and I'll pay the subcontractor for the work that you've done to that point, and I will not pay you for any of the lost opportunity costs that you may have had if you were to complete that project. So in this situation, subcontractor says, sub, you're fired, I'll pay you for what you've done, the rest, you're out of luck. An example 2, if we can move that slide, the contractor may, at its sole discretion, by written notice to subcontractor, terminate this subcontract in whole or in part when contractor determines that it is the best interest of contractor to do so. Essentially, this is a get out of jail free card for the GC, because it's whenever it's in the best interest. I mean, of course, it's they're going to do it whenever it's benefits their bottom line. So this goes on to say, Upon receipt of 24 hours written notice from contractors, subcontractors shall take all reasonable measures after consultation with contractor to terminate or at contractor's option assign to contractors subcontracts, purchase orders, and so on. So what this is saying is you're off the project. You may have done nothing wrong, but I want you out, and this is my way of doing it without any real liability. So normally termination for convenience clauses are used in two different situations. So let's look at the first. The first situation is when a subcontract has begun work and under the subcontract, and the GC has found a different subcontractor to complete the work. So let's just say you win the bid for drywall on a project. The GC usually uses a different drywall company, but they're unavailable. They're too busy at this time. You're midway through the project, and they want to use their guys who could probably do it. That they know their work. They can probably do it at a cheaper rate. They're going to get you out of there, and they're going to bring in their go-to guys. So when this happens, you normally receive a letter from the GC informing you you've been terminated for convenience, and they no longer need you on the project. Unfortunate, but it's something that they may have at their disposal, but depending on the contract. Now, the second situation of the termination for convenience clause is used when the GC has wrongfully terminated the subcontractor and just needs the get out of jail free card. This means that the GC has fired you for no good reason. Whatever their reason is, it may not be justifiable, but this is the way they can say, you're out, don't need to explain it to you, this is what I'm doing and why, and you're just out of luck at that point. If we can move on to the next slide. So this is an example that, from personal experience with a firm. A drywall subcontractor was hired on a project that required special badges to enter the project. One day, the subcontractor showed up for work, and the project manager took away their badges without any explanation. So the drywall contractor then sent several emails to the GC and asking what's going on, why don't they have their badges, how can they get back to work. GC never responds. So we contact the GC demanding the money that the client is owed, and stating that there's been a wrongful termination. The GC responds saying it doesn't matter why I fired him. We could just say it's termination for convenience, their best interest, and that's how they get out of jail free. The subcontractor didn't do anything wrong, but for whatever reason, the GC has this clause in the contract that allows them to do this type of behavior. Although unfair, that is why it's so important for you to understand what you're getting into before you sign that contract. And I understand that general contractors have all the leverage in these situations. We all know that subcontractors, they bid on these projects and they know there's 10 subcontractors right beside them who will do almost anything to get that job. So sometimes subcontractors are apprehensive about questioning the contract or even trying to amend the contract. But I promise you, it's in your best interest to understand everything. Even if you can't change it, you really got to know what you're getting into. But it never hurts to try to at least request a change in the contract. The worst thing they do is say no, and you're back to where you started, and you get to get back to work. So like I said, it's always a good idea to be aware that this clause exists and try to get rid of it. Ask the GC if you'd like, before you sign the contract, hey, I'm on board with this, but I just need this one clause removed. If they give you pushback, which they likely will, you're going to want to at least negotiate there and say, well, I'd like the same clause on my behalf. The subcontractor can exit if it's in their best interest. At least you're trying. It may not be successful, but you know what you're getting into, one, and two, you're trying to change it and protect yourself. Okay, so let's talk about if you do get terminated. If you're terminated and are still owed money from work you've already performed, the general contractor does not have to pay you. The payments can stop. And that is, of course, again, that doesn't seem fair. But in this situation, when you sign that contract, excuse me, Essentially, you promised to do a certain scope of work for a certain amount of money. You made that promise to the general contractor. Now, if you get terminated, the general contractor is going to hold you to the promise, even though you've been terminated from the job. It's all part of their bottom line. So if you said you're going to do drywall for 10,000, they're going to hold you to it until that drywall has been accomplished for that 10,000. So legally, they get to retain the funds until that promise is either fulfilled, or it's never going to be cheaper than what you bid. But if it is, okay, you're in the clear. But most likely, the completion of that project is going to cost more than what you bid, and that's what I think we're going to talk about in this next slide. So, okay, you've been terminated. The GC is going to go out and hire a subcontractor to complete your work, like we discussed. Now, something to keep in mind: the price of the replacement contractors is almost always more. Now, think about that. Now, if you've been terminated, and now there's a bunch of subcontractors looking to take over that project. One, they know you've been terminated, most likely, and two, they know that the GC is in a tight spot, probably on a tight schedule, and needs the work done. So they're not going to come in with a low bid. They know that they got leverage here. So most likely that bid to complete your work is going to be more than what you initially bid. Also, general contractors can add administrative fees. In most subcontract, there's a provision that allows the GC to add a fee to the cost of the new subcontractor. So if they got to go out and get a new sub to finish your job, there's going to be a 10 to 15% additional cost that's already inserted into the contract that you signed, giving them permission to do so. So we'll move on. So it's highly unlikely that once you're terminated, the GC can complete your scope for the work of that price, like we said. So because of this, general contractor can demand that you pay the additional cost to complete the scope of the work of the new contractor. If you refuse, they can take you to court or arbitration to recover their damages. So again, you've been terminated. The new drywall guy comes and he completes the job for $5,000 over what you bid. The GC is going to hold you to that promise, that the contract that you signed, even though you were terminated, and you potentially could be held liable for the additional $5,000. That's why it's so important for you to know what you're getting into. If you get the default notice, you know exactly what to do. Respond in writing, explain yourself, remedy the situation. Unfortunately, if you get terminated by one of these clauses, there's other ways to protect yourself in these situations, just besides a breach of contract, because that does get complicated and most likely leads to litigation. But there are other avenues, such as your lien rights. As we've discussed in many other webinars and our lunch and learns, if you enact your lien rights, you have a greater chance of being paid, especially on projects where you've been terminated, either for cause or convenience. Once terminated, you need to initiate that lien procedure. And as you probably know, there are very strict requirements when following these procedures and creating a valid and enforceable lien. Even missing a deadline by a day, you can't get a valid lien on the project. So when it comes down to these situations, default or termination, again, remember that these contracts were written by lawyers to protect the GC. I always say if it's written by a lawyer, it's a good idea to have it read by a lawyer. At least you can understand the potential pitfalls that you may run into and know how to act in case one of these unfortunate situations, if they arise. I believe that is the end of our slideshow. But again, we are open to any questions you might have, and hopefully I can answer them. If not, I can always find the answer for you.
Thank you, Joseph. Really appreciate it. Great presentation. And as Joseph said, please feel free to message us in the chat any questions you may have, or you can unmute yourself and ask directly. Any questions at all for Joseph? All right.
That means I covered
Okay.
it really, really well. No questions.
Oh, no, that's good. Yeah, you did.
Yeah,
And Thomas
good.
Carpenter actually just sent a message. So he said, how common is the convenience clause now? He's not seeing many of them in, he's not seeing it in most of the contracts.
You know, it depends on like what region, but they're pretty common, especially on larger projects. But if you're not running into them, then that means you're reading your contract pretty well and you're aware of what's in and what's not. So you're already doing the right thing.
Thank you. Great question, Thomas. Is any other questions for Joseph? This is your opportunity to ask licensed attorney any and all questions you may have to best protect yourself. All right, we have another one come in. Oh, thank you. Thomas said, great information. I'll definitely be reading carefully in the future. Awesome. Yes, this is definitely, that's all we want. That's all we want for everyone is, you know, to best protect yourself on the front end so that you're not dealing with costly litigation in the end. What we want to definitely avoid. Well, thank you so much. So if we don't have any other questions, again, this is recorded, so I'm going to be posting on our Facebook and our YouTube channel. I'm also going to send a follow-up email with the presentation and with Joseph's contact information. So if you do have any questions for him, please feel free to reach out. And we really thank you for your time today and hope you have a great rest of your week.
Thank y'all.
Thanks, Joseph. Thanks, everyone.